Good afternoon, class. Today's lesson is Title 3 of the Revised Corporation Code of the Philippines. We will talk about the Board of Directors as applicable to stock corporations, the Board of Trustees as applicable to non-stock corporations, and also officers. So remember, class, before we begin with the board as a governing body, we have to discuss the 3 levels of control in a corporation. So remember, primarily in control of the corporation is the board of directors or trustees. So remember, yung board of directors or trustees, they will exercise all corporate powers which are provided for in the Revised Corporation Code, and also as well as the Articles of Incorporation and the bylaws. So remember, the Board of Directors will conduct all the business of the corporation, and it will hold all the property of the corporation. So what else? Also remember, the second level of control are the officers of the corporation. In theory, they will execute the policies laid down by the board of directors or trustees. However, in practice, remember, they have a larger or wider latitude in determining business policies of the business operations of the corporation. Now, the last level of control is yung mga stockholders. Remember, the stockholders or the members, they have residual control or residual power over the corporation, because some acts, some corporate acts cannot be performed without the consent of the stockholders or members. So when it comes to fundamental corporate changes, remember, kailangan ng boto ng stockholders or members. That's why they have residual control over the affairs of the corporation. Now, remember also that corporate powers are exercised by the board of directors or trustees. And remember also that the board of directors or the board of trustees are the governing body of a corporation. So, bakit governing body ang board of directors? Because corporation, being a juridical person, cannot act by itself, kasi nga they are invisible. They exist only in the mind of the law. And remember, if they will act and contract only through the aid or by means of individuals. So, syempre, hindi naman pwedeng bumoto yung mga juridical persons. Kailangan talaga mayroong natural person who will transact with third persons. So, also, in addition to the board, pwede rin namang a corporation can also act through agents or officers if they are authorized by the board of directors or trustees via a board resolution or by the bylaws. What else? Please remember also the business judgment rule. So if the board of directors or the board of trustees are in control of the corporation, the next question is, can the courts interfere with the policy-making decisions of the board of directors or the board of trustees? Now, as a general rule, class, remember, the courts cannot undertake to control the discretion of the board of directors or the board of trustees, for that matter, about administrative matters as to which they have legitimate power of action. The reason why we elect yung members of the board is because we assume, as stockholders or as members, we assume that they are knowledgeable about the affairs of the corporation. They know how to control it, they know how to manage it. So, kung meron mang may alam kung paano patakbuhin ang corporation, it would be the members of the board. Now, the courts, hindi naman talaga nila alam yan eh. So, as a general rule, yung mga acts ng mga board of directors, if they are entered into intra vires or within the power of the corporation, they are binding to the corporation. And as a general rule, the courts will not interfere with the control and discretion of the board. What is the exception? If the acts are so unconscionable and oppressive as to amount to a wanton destruction of the rights of the minority stockholders. So as long as there is good faith on the part of the board, hindi makikialam ang courts dyan sa administrative actions ng board. So there is a presumption also that the acts are valid and regular. What else? Please remember also the limitations on the power of the board of directors or trustees. There are limitations imposed by the Constitution, by statute, or by the Articles of Incorporation, or by the bylaws. What else? it cannot perform constituent acts which yung involving fundamental changes in the corporation. So remember, if it involves fundamental changes in the corporation, it needs the ratification or approval of the stockholders or members. Because remember, again, as I've said before, the stockholders or members have residual power over fundamental changes sa corporation. What else? It cannot exercise powers not possessed by the corporation. So, any power not possessed by the corporation, ultra vires yan. So, they cannot be exercised by the board of directors or board of trustees. Remember also that in case of exercise of the powers of the board, they will exercise it as a body. Now, how can they exercise powers as a body? Remember, in a lawful meeting, not individually or separately. So, kailangan, if there is corporate action, it must be an act at a meeting which is properly called and there is a quorum. So, hindi pwedeng isa-isa, hindi pwedeng, kailangan mag-meeting sila. Bakit? Because there is opportunity for discussion and exchange of views, and also kailangan talaga they act as a body. Yan. So, individually, they have no power to bind the corporation. So, remember that. What else? Exceptions. Ito yung exception sa general rule. Remember, the board as a governing body must act as a body in a properly called meeting. Yan. So, yun ang kailangan nating tandaan. Subject to exceptions. Now, these are the exceptions. Number 1, if the contract is entered into without a meeting and the directors happen to be the sole stockholders. So, lahat ng directors, sila din yung stockholders. So, ngayon, kung the meeting is not properly called, they are not acting as a body. Anyway, sila-sila lang naman eh. So, contracts entered into even without a meeting, binding yan if the directors happen to be the sole stockholders. What else? If the contract is entered into by a corporate officer, if there is authority from the board of directors. Remember, the authority may be given expressly or impliedly. What else? If the transaction is ratified in a subsequent board meeting. So when the transaction was entered into by an officer, by an agent of the corporation, or maybe by a member of the board, hindi siya authorized or whatsoever. But remember, in a subsequent meeting, the action is ratified. So it is binding on the corporation. Even if noong ginawa yung act na yan, the board is not acting as a body in a duly constituted meeting. What else? Bylaws may create an executive committee. So, ang executive committee, pagka nag-meet yan, hindi naman board meeting yan eh. Kasi ang board meeting, it comprises all of the members of the board. So, pagka executive committee, which we will discuss, I think, in section 34, binding pa rin yan. Because remember, yung executive committee is duly authorized by the bylaws, and they will act only on specific matters which they are authorized. Merong mga matters which the executive committee cannot act upon. What else? Also, if the corporation enters into a management contract under section 43, so here the management of the affairs of one corporation is delegated to another corporation. So, yung board of directors ng specific corporation na to, let us say Corporation A, enters into a management contract with Corporation B. Corporation B will manage the affairs of Corporation A. So, itong board, itong affairs ng Corporation A, hindi kinokontrol, yung management niya hindi kinokontrol ng board ng Corporation A. So, ang nagko-control is yung board ng Corporation B. So, even if the board of Corporation A does not act as a body, yung mga acts ng Corporation B which manages yung Corporation A is binding on the on Corporation A. So what else? In case of a closed corporation, directors may act without a meeting. Walang problema yan. Remember also, in cases mentioned in section 100, which we will discuss later, yung kanilang acts will be deemed valid or ratified. What else? Also, remember the powers of directors or trustees to delegate authority. So, the general rule is that they can delegate yung kanilang power. So, Remember here that the board of directors or trustees, yung kanilang power may be delegated expressly or impliedly. Kanino? To officers, to agents, or to an executive committee. So, yung power kasi ng trustees at saka directors is an original power. So, they can delegate it further. Hindi katulad ng delegated power. You cannot further delegate yung delegated power. So, what else? Also, remember the exceptions. Number 1, in case of discretionary powers. So, discretionary powers, they are vested exclusively in the board of directors and cannot be delegated to subordinate officers. So, yung mag-exercise sila ng decision making, yan. Hindi pwedeng i-delegate yan sa mga officers, agent, but purely ministerial, yung hindi na kailangan mag-isip, it may be delegated. What else? The board of directors cannot delegate entire supervision and control of the corporation to others. Yan. Number 3, powers specially conferred cannot be delegated by mere resolution. What else? And also, power of the board to delegate subject to restriction as may be provided in the bylaws. Term of office, also under Section 22, remember as a general rule, directors should be elected for a term of 1 year until their successors are elected and qualified. In case of trustees, their term is not exceeding 3 years, again, until their successors are elected and qualified. Now, remember yung portion na until their successors are elected and qualified, this is known as your holdover principle. So, if there is no qualified director yet, there is failure of a quorum, there is failure to elect at a meeting, yung mga incumbent, yung nakapwesto ngayon, they will naturally hold over yung position of director and trustee and will continue to function as such director or trustee until new directors or new trustees are chosen and qualified. Remember yung term na and qualified. So, pagka hindi pa nakapag-elect ng mga bagong directors, bagong trustees, yung mga incumbent, yung nakapwesto ngayon, they will hold over the position until new directors or trustees are elected and qualified. Now, what else? Now, what is the term now of yung, halimbawa, nag-hold over yung mga directors and trustees, nag-extend sila ng 2 months. Directors na lang, nag-extend sila ng 2 months. Remember, the term of office of a director is 1 year. Now, hindi sila nakapag-elect. There is failure to elect yung mga replacement directors. So, nag-hold over yung mga incumbent for 2 months. After 2 months, nagkaroon ng bagong directors. Now, the question is, how long is the term of the new director na na-elect after 2 months from the date of expiration of the term of the incumbent? So, remember, yung kanilang term of office is only 10 months. So, kakainin yung sa pangalawang, dun sa susunod na term. Remember, class, hindi naman extension yun ng term ng original or yung mga nakaupo. Pero kasi, remember, class, na holdover lang naman yun kasi wala pang na-elect na mga bagong directors or bagong trustees. So, usually, they elect the directors or trustees during the annual meeting of the corporation. So, the number of directors or trustees to be elected, it depends. So, in a stock corporation, shall not be more than 15. In non-stock corporations, may or may not be more than 15. In case of a closed corporation, tandaan nyo na a closed corporation may choose not to elect yung board nila and all of the stockholders will manage the corporation. What else? Also in case of non-stock educational corporation. So in case of non-stock educational corporations, not less than 5 nor more than 15, provided that the number shall be in multiples of 5. So with the term of office of 1/5 of their number expiring every year. So anyway, I will discuss this later on when we go to non-stock corporations. So, ang kailangan nyo lang tandaan sa non-stock educational corporations is that yung kanilang term of office is ang kanilang number of trustees pala is not less than 5, not more than 15. Tapos yung term of office is yung number ng total number ng trustees, yung kanilang term of office will expire every year. Ito yung tinatawag nilang staggered expiration ng term. So we will discuss that later on. What else in a corporation whole? Obviously, there is no need for a board of trustees because there is only one member, one corporator. And in case also of a one-person corporation, because the one person is the sole stockholder, is also the director and also the president of the corporation. What else in case of the board of trustees of religious society, not less than 5 nor more than 15. We will discuss that later on. What else? The qualifications naman of directors or trustees. So, remember, for stock corporations, for directors, ang kanilang qualifications is that they must be of legal age, they have legal capacity, obviously, they will enter into contracts, kailangan yan. What else? Director, including an incorporating director, must own at least 1 share of the capital stock. What else? The share of stock must be held in the name of the director, and it must be registered in the name of the director in the books of the corporation, and must continuously own the share during his term. So, kung binenta niya yung share na yan, he is no longer a director, disqualified na siya. What else? Also add yung qualifications provided for under, disqualification actually provided for under section 26, which we will discuss later on. For non-stock corporations, the requirements, the qualifications are simpler. Must be of legal age, must be a member in good standing of the non-stock corporation, and number 3, again, add the disqualification provided for in section 26. Also remember that additional qualifications may be imposed on directors or trustees as long as it is provided in the bylaws. Also, yung mga qualifications provided for by the revised corporation code, hindi mo siya pwedeng kontrahen. So, any qualifications which will modify yung qualifications which are given by the revised code, remember, hindi siya pwede if it is in conflict. So, additional qualifications as long as they are not in conflict with the revised corporation code. What else? Please take note also of independent directors. So, independent directors are independent from management and free from any business or other relationship which could reasonably be perceived or to materially interfere with the exercise of independent judgment in carrying out their responsibilities as a director. So, remember, sa mga independent directors, usually they are elected in cases of corporations vested with public interest. So, if the corporation is vested with public interest, dapat yung kanyang board of directors should constitute at least 20% na independent director. So, if you have 10, kailangan at least 2 ay mga independent directors. So, remember, ang independent director, apart from shareholdings and fees, yun lang natatanggap niya sa corporation, wala na siyang ibang connection sa corporation, which will affect his judgment doon sa management ng corporation. So, also, it applies to non-stock corporations. What else? So, corporations vested with public interest under Section 22 are those covered by the Securities and Regulations Code. Yung may mga securities which are registered with the SEC. What else? Number 2, banks, quasi banks, non-stock savings and loans associations. So, pawn shops, corporations engaged in money service business, pre-need trust and insurance companies and other financial intermediaries. So, any corporation which receives money from the public are considered as corporations vested with public interest. What else? Other corporations engaged in business vested with public interest, similar to those already mentioned above. So, yun ang kailangan nating tandaan sa mga corporations vested with public interest. In case of elections naman of directors or trustees, so remember, these are the limitations or the rules. Each stockholder or member shall have the right to nominate any director or trustees who possesses all of the qualifications and none of the disqualifications set forth in the revised corporation code. So, yun ang unang kailangan nating tandaan. Tapos, yung mga directors or trustees must be elected in a meeting. So, yung meeting na yun is specifically to elect yung mga directors or trustees. And also, there must be present majority of the outstanding capital stock or majority of the members entitled to vote. What else? Remember, sa voting manner, it may be personally or number 2, through a proxy, which we will discuss when we go to Title 7, and or through remote communication or in absentia. More in Title 7 sa mga manner na to. So, in case of a stock corporation, the voting is on the basis of number of share. 1 vote per share, and it is not based on the number of stockholders. So, if one stockholder owns 80% of the corporation, boto pa lang niya is sufficient to elect a director or a trustee. What else? To elect a director pala in case of a stock corporation. What else? Stockholder cannot be deprived of his right to use any of the methods of voting in the election of directors. In case of a delinquent stock, he will have no right to vote. And non-stock corporations may cast as many votes as there are trustees to be elected and may not cast more than 1 vote for 1 candidate. So, if there are 5 trustees to be elected, each member has 5 votes. Now, itong 5 votes na to will be distributed into 5 candidates. So, yun ang tandaan natin sa non-stock corporations. General rule, election may be through any manner, but if there is a request that the election must be by ballot, doon lang magkakaroon ng voting by or election by ballot. What else? Quorum is present dun sa meeting to elect. The candidates who will receive the highest number of votes will be declared yung elected. Plurality only, not majority. In case there is a failure to hold an election for whatsoever reason, merong kailangan na report na i-file sa SEC 30 days from the date of the scheduled election. So yung report na yon will specify a new date for election which shall not be less than 60 days from the originally scheduled date. So what else? The requisite notice for the election must be given before the scheduled meeting. So yun ang tandaan natin sa election of directors or trustees. Also, methods of voting, tatlo to. Although in some books they just discussed 2, straight and cumulative. Here in the book of De Leon, he differentiated yung dalawang klase ng cumulative voting, although it's the same thing. Straight voting, every stockholder may vote such number of shares for as many persons as there are directors to be elected. So, remember in case of straight voting, if a stockholder owns, let us say, owns 100 shares of stock, so meron siyang ilang votes. Kung halimbawa merong 5 na directors to be elected, meron siyang 100 shares of stock. So remember, merong 500 votes si A. 100 shares of stock times 5, which is the number of directors to be elected. So A has 500 votes. Except that in straight voting, yung kanyang number of votes will be divided into as many candidates as there are to be chosen. So, in case of straight voting, the votes are distributed equally among the 5 candidates. So, remember, meron siyang 500 votes, but yung 500 votes niya will be distributed equally among the candidates. So, again, babalik tayo dun sa 100 votes per director. So, yun ang straight voting. So, what else in case of cumulative voting for 1 candidate? So, cumulative voting is available only to minority stockholder. So, in case of cumulative voting for 1 candidate, imbis na i-divide into the number of directors to be elected, yung kanyang 500 votes as in our example a while ago will be cumulated for 1 candidate. So, remember, imbis na 100 shares times 500 times 5 directors equals 500 votes divided by 5, which is the number of directors to be elected, equals 100 votes per director. In case of cumulative voting for one candidate, remember, 100 shares times 5 directors to be elected, pero yung equal to 500 votes, pero yung kanyang 500 votes will not be divided equally into 5 candidates, but will be cumulated for one candidate only. So yun ang tandaan natin. In cumulative voting by distribution naman, stockholder may accumulate his share by multiplying also the number of shares and by the number of directors to be elected, and distribute the same among candidates as he may deem fit. So here in by distribution, again, A has 100 shares times 5 directors to be elected. So meron siyang 500 votes. Pero yung distribution ng kanyang 500 votes, hindi again it's not for 500 persons, but he may distribute it to 3 directors, 4 directors, yan. So distribute it in such manner as he may see fit. For 200 para kay A, 200 para kay B, dalawa lang ang kanyang inelect pala, 500 pala, no? So plus 100 kay C. So ganun ang cumulative voting by distribution. So anyway, in case of cumulative voting, remember also minority stockholders can join yung kanilang mga votes together. So if A and B are majority stockholders, C, D, E, and F are minority stockholders, pwedeng ipagsama-sama ni C, D, E, and F yung kanilang total number of votes and concentrated into one candidate para makapagpasok sila ng director sa board, kasi nga sila ay mga minority. Anyway, I will give you an example when we go to class on Saturday. In a non-stock corporation, remember the voting is each member may cast as many votes as there are trustees to be elected, but not more than 1 vote for one candidate. So if there are 5 trustees to be elected, merong 5 votes ang isang member. But again, 1 vote per trustee. So yun ang kailangan nating tandaan in case of a non-stock corporation. I will give examples later on. It's a very long example. Doon na lang sa ating class on Saturday para sa cumulative voting. But what you have to remember about cumulative voting is that it is available only to minority stockholders, and to ensure them of representation in the board of directors. Also, yung mga directors elected because of cumulative voting cannot be removed without just and lawful reason. Yeah. What else? Voting through absentia also, remember, pwede yan when it is authorized in the bylaws. Voting through remote communication or through absentia is allowed in case it is allowed in the authorized in the bylaws and authorized by majority of the BOD. In case of corporations vested with public interest, it is allowed even if there is no provision in the bylaws of the corporation that absentee voting or voting through remote communication is allowed. Allowed pa rin yan pagka, kahit na walang provision sa bylaws in case of corporations vested with public interest. In case of corporate officers under Section 24, ang corporation, once it is incorporated, it will formally organized by the election of directors, trustees, and officers. Ang directors class, ang nag-e-elect niyan is yung mga stockholders. Ang mga trustees naman, ang nag-e-elect niyan is yung mga members. Now, yung mga officers, they are elected by the directors or the trustees depending on what kind of corporation it is. Now, the next question is, sino ba ang mga corporate officer? Ang mga corporate officer is yung persons who occupy a position that is expressly mentioned in the revised corporation code or in the bylaws of the corporation. So, in addition to the positions that are defined under the code, pwede namang magdagdag ng positions at ilalagay natin ito sa bylaws. Now, pagka nakalagay sa bylaws ito, all of these persons occupying yung positions provided for in the bylaws and also in the revised code, they are considered as corporate officers. Now, kung yung position mo is not defined in the bylaws or defined in the code, you are a mere employee of the corporation. Subordinate ka lang, empleyado ka lang. Now, in 24, remember, yung mga officers which are provided for in the revised code are the President, Treasurer, Secretary, and also Compliance Officer, if you will read ahead yung Section 24. Now, in case of officers, ang tandaan nyo dyan is yung task of actual management and carrying on the details of business operation and corporate policies, sila ang gumagawa. So, mas hands-on sila. So, yun ang kailangan yung tandaan. Because the powers of management and business operations, dine-delegate yan usually sa mga officers. Now, what else? Binding on the corporation as long as it is intra vires, yung mga acts ng corporate officers. If they are acts ultra vires, they cannot bind the corporation unless they are ratified or the corporation is in estoppel. What else? Compensation of in term of office of officers. So remember, compensation, syempre, it is fixed by the board of directors. Syempre, sila ang nag-appoint niyan. Obviously, they have to fix the salaries for the officers that they appoint. Now, pwede rin daw bonuses subject to the term of reasonableness. Also, term of office is fixed in the bylaws. Otherwise, they will be deemed elected for 1 year, and again, yung holdover until their successors shall have been elected. Mga officers, because they are appointed by the board, they may be removed at any time. Now, also, what you have to remember is that where the term of an officer as fixed in the bylaws or in a contract exceeds 1 year, he has to be re-elected by the incumbent board. So, kung gano'n ang, remember, ang board, 1 taon lang yan. Tapos yung mga officers, kung lalagpas sila ng 1 taon, they have to be re-elected by the incumbent board. What else? Positions concurrently held by the same person. Here in Section 24, remember, 2 or more positions are held by the same person. Pwede yon, it's allowed, except in 2 cases. The positions of President and Secretary and President or Treasurer at the same time, because of the inherent incompatibility with one another. So, yun ang tandaan natin sa 24. What else? No prohibition, stockholder being a director or officer in 2 or more corporations. Walang problema yan. Also, the revised code does not prohibit a corporate officer from occupying the same position in another corporation organized for the same purpose. So usually this is not prohibited in the revised code, but this may be prohibited in the articles or in the bylaws or in special laws. What else? Corporate officers, these are the enumeration of the corporate officers. So, yung President, Vice President, Secretary, Treasurer, also General Manager, and Compliance Officer. So, anyway, please learn to define them. Probably will ask them on Saturday. Section 25, the reports submitted to the SEC. So, the report of election, ito yung pinag-uusapan talaga sa Section 25. So, the reports to be submitted to the SEC yung number 1, the report on the names, nationality, shareholdings, and residences, addresses of the directors or trustees and officers elected. So, pagka-elect nila, within 30 days, kailangan makapag-submit na ng report ng kanilang information. Yan, names, nationalities, etc., etc. Doon sa SEC. Usually, it is the corporate secretary or any other officer who will submit this to the SEC. What else? If in case there is an annual election, annual meeting, usually sa annual meeting, dun ginagawa yung election. Ngayon, if there is non-holding of election or there is a failure to elect yung mga bagong board, of course, the SEC must be notified. So, the notification or the report on the non-holding of election must be submitted within 30 days from the date of the originally scheduled election. Now, dun sa report ng non-holding of elections, kailangan meron ka ng bagong date. So, new date of election which shall not be later than 60 days from the originally scheduled date. What else? In case a director, trustee, or officer dies, resigns, or in any manner ceases to hold office, kailangang i-report din yan sa SEC. So, it is the corporate secretary or any director, trustee, officer of the corporation who may report it to the SEC. In case of death, yung of any director, trustee, or officer, even the heirs of such deceased director, trustee, or officer may report such fact to the SEC within 7 days from knowledge thereof. What else? In case of non-holding of election, binigay itong power na ito sa SEC. This is a brand new power granted to the SEC in case there is a non-holding of election. So in section 25, di ba, sabi ko nga sa inyo, you have to report yung non-holding of election within 30 days from the originally scheduled date. Kailangan i-report ng corporation yan. Now, the SEC may order an election in case, number 1, no new date has been designated in the report submitted to the SEC, or number 2, yung rescheduled election is likewise not held. So, yung SEC may, upon application of a stockholder, merong nagreklamo, merong nagsabi na, oy, wala pa kaming election, etc., etc. Any stockholder, member, director, or trustee may apply to the SEC for an order na sila ay mag-hold ng election. So, the SEC will verify yung unjustified non-holding of election, and it will issue a summary order to hold an election. So, yung together with this power, the SEC will also have such other powers which and may issue such other orders as may be appropriate. So yung orders niya to direct issuance of notice na nakalagay yung time and place of election, magde-designate ng presiding officer, also the record dates or dates for the determination of stockholders or members entitled to vote. Please take note of the definition of record date. Ito yung date na i-designate sa notice of meeting kung saan titignan na kung sino ang qualified to vote doon sa next election. So, obviously, if it is a stock corporation, titignan sino ba yung mga stockholder na hindi delinquent ang subscription. So, yan ang pwedeng bumoto. As of this date, itong record date na to. So, sino ang qualified. Tapos, pagdating naman sa members, sino ba ang members na hindi delinquent, nakapagbayad ng mga membership fees, etc., itong date na to, as of this date, sino ba ang hindi delinquent, sino ba ang outstanding members. So, they will be entitled to vote in the election. So, yun ang kailangan nating tandaan sa report ng election. So, what else? Also, in addition to that pala, any provision in the Articles of Incorporation or bylaws to the contrary, only yung shares of stock or membership represented during the meeting na kinol ng SEC will be sufficient to constitute a quorum. So let us say in a corporation nakalagay 80% dapat ang attendance bago magkaroon ng quorum. Regardless of such provision in the articles or in the bylaws. Basta kung sino lang ang nag-attend doon sa meeting na yon who are entitled to vote, quorum na yon for the purposes of conducting an election called by the SEC under this section. So, Section 26 provides for the grounds for disqualification of directors or trustees or officers. Obviously, this is to prevent yung unworthy individuals from being elected or appointed as directors or trustees or officers. So, the grounds are found, as I've already mentioned, in Section 26, in number 1, if within 5 years prior to the election or appointment, the director, trustee, or officer was convicted by final judgment. Remember, the operative word is convicted by final judgment of, number 1, an offense punishable by imprisonment for a period exceeding 6 years. So, exceeding 6 years. If it is exactly 6 years, remember, the provision does not apply. But if the offense is punishable for a period exceeding 6 years, so pataas ng 6 years or more than 6 years, yan. Remember, class, and there is conviction by final judgment, this person is disqualified to become a director, trustee, or officer. What else? In cases of violation of the revised corporation code, in number 2, remember, if the disqualification is based on a violation of the revised corporation code of the Philippines, the duration of the imprisonment is immaterial. What else? In case of number 3, there are violations of the Securities and Regulation Code. Here, class, there is no clear-cut instruction. Basta sinabi lang, for violation of the Securities Regulation Code, any violation committed within 5 years prior to election or appointment will disqualify a person from becoming a director, trustee, or officer. What else? Number 2, 5 years again prior to the election or appointment, the person is found to be administratively liable for any offense involving fraudulent acts. So again, disqualified. And also within the same time period of 5 years prior to election or appointment, such person is found liable by a foreign court or equivalent foreign regulatory authority for acts, violation, or misconduct similar to those enumerated in paragraphs 1 and 2 of this section. So remember, class, any conviction by final judgment, any violation involving fraudulent acts, if committed 5 years prior to election or appointment, such person is disqualified from becoming a director or trustee or officer. How about section 27, the removal of stockholders or members? So obviously, the power of the stockholders to remove directors or trustees. Obviously, class, you cannot remove a stockholder. Stockholders cannot remove a fellow stockholder. So yun ang kailangan nating tandaan. Here, the stockholders or the members will remove a director or a trustee. So the general rule is there is no specific reason that is required for the removal of any director or trustee. Kasi nga, sila naman ang nagupo dyan. Any reason is sufficient for them to be removed. So here, remember, the law does not specify cases for removal of a director or trustee, and it does not even require that removal should be for a sufficient cause or reason. So, for any reason, except, remember also, here, in case a director or trustee is elected by cumulative voting, they cannot be removed without just and lawful cause. So, even if there is the prescribed vote, pero kung ang director or trustee is elected by cumulative voting, and such removal will deprive the minority stockholders or members of representation to the board. Remember, class, hindi pwede if it is without just and lawful cause. Yan. For the protection of minority stockholders against abuse. Yan. What else also? Remember, class, that the SEC also has power to remove director or trustee. In your book, you will see that the board does not have the power to remove a director or a trustee. So, yung mga director or yung mga trustee, hindi sila pwedeng tanggalin ng kapwa nila director or trustee. Also, remember in your book, the court cannot remove also yung director or trustee. It is not within the scope of the power of the courts to remove a director or a trustee. In addition to that, remember that the SEC, based on the revised corporation code, now has the power to remove directors or trustee. So remember, the SEC shall motu proprio or upon verified complaint. Motu proprio, it's on its own account. So siya mag-isa, parang voluntarily, based on its own discretion, or if there is a verified complaint after there is notice and hearing, the SEC may order the removal of a director or trustee who is elected despite the fact that he is disqualified. So, or after electing yung sinabing director or trustee, doon siya na-discover to be disqualified, or yung kanyang disqualification arose after the election. So, also in addition to that, remember section 160, mayroong liability. So, a director, trustee, or officer who willfully holds office or willfully conceals yung disqualification shall be punished by a fine ranging from 10,000 to 200,000 at the discretion of the court, and shall be permanently disqualified from becoming a director, officer, trustee of any corporation. So if it is injurious or detrimental to the public, such violation will be fined to 20,000 to 400,000. So in addition to removal as a director or trustee, based on an order of the SEC, pwede pang magkaroon ng punishment, fine imposed by the court. So yun ang tandaan natin sa Section 26 in relation to Section 160. Section 27 in relation to Section 160. Also, please take note of the requisites for removal. The removal must take place at a meeting, regular or special. But else, previous notice to the stockholder or members of the intention to propose such removal. So, mayroong written notice or publication noong time and place of meeting. But else, the removal must be by a vote of the stockholders holding or representing 2/3 of the outstanding capital stock, or if it is a non-stock corporation, by 2/3 votes of the members. What else? A special meeting for the special meetings of the stockholder or members of a corporation must be called for the purpose of removing director or trustee, must be called by the secretary on order of the president. Or kung ayaw alisin ng, kumbaga, if the president does not want to order a meeting for the removal of a director or trustee, it may be based on a written demand of the stockholders representing or holding at least majority of the OCS or majority of the members entitled to vote. What else? Number 5, the removal must be reported in writing by the corporate secretary or director or trustee or officer of the corporation to the SEC within 7 days from knowledge thereof. So also, please take note that in case of resignation, as a general rule, it is effective immediately. Yan. So, even if wala pa siyang successor, pwede namang mag-resign ang director or trustee at any time, except if it is a part of a fraudulent scheme. So, pwede siyang magkaroon ng magbayad ng damages if yung kanyang resignation is part of a fraudulent scheme, which will leave yung corporation vulnerable. What else? Resignation must be reported also in writing by the corporate secretary within 7 days from knowledge. Abandonment, remember, and failure to attend meetings. So, in case of abandonment, nagkakaroon ng abandonment if there is an acceptance of an incompatible office. So, director ka ngayon, tapos bigla tumanggap ka ng position which is in conflict with your duties as a director. There is a presumption of abandonment. What else? Absence for unreasonable length of time. There is a presumption of, there is implied resignation of his office as a director. So here, abandonment again, implied resignation. How about the filling of vacancies? So remember, this is filling of vacancies. In Section 28, sabi niya, yung tenure ng replacement director or trustee is only for the unexpired term of the predecessor in office. So remember, yung term ng isang director is for 1 year. Now, if after 8 months nag-resign itong director na to, yung kanyang kapalit, meron lang siyang tenure na 4 months, only the unexpired portion of the term of the originally elected director or yung predecessor in office. In case of a trustee naman, the term of office is 3 years. Now, if your trustee serves for 2 years, yung tapos bigla nag-resign siya or tinanggal siya, he was removed, or remember here, class, that if that is the case, yung tenure ng kanyang successor in interest is only for a period of unexpired portion of the term of the predecessor in office. What else? Filling of the vacancies. Pwedeng dalawa ang gumawa niyan. The vacancy may be filled by the remaining directors or trustees, or the vacancy must be filled by the stockholders or members. So, number 1, if there is a vacancy, it is filled by the stockholders or members based on the following grounds. If the vacancy results from the removal of stockholders by the stockholders or members or expiration of term. So, tandaan nyo, pagka ang isang director or ang isang trustee ay tinanggal ng mga stockholder based on the procedure found in section 27, or nag-expire yung kanilang term, the vacancy must be filled by the stockholders or members. Yan. So, yun ang tandaan nyo. The replacement must be elected by the stockholders or members. Yun nga, yung mga kapalit, sila ang bahalang mag-appoint or mag-elect. What else? If the vacancy is created by reason of increase in the number of directors or trustees, so here is an amendment of the articles to increase the number of directors or trustees. So, if the directors or trustee dati 5 lang sila, ginawa mong 10. So, you have to elect additional 5 directors or trustees. Now, yung additional na to, yung additional 5 should be elected by the stockholders or the members. So, shall be filled only by an election at a regular or special meeting of stockholders or members duly called for the purpose. Or pwede rin namang i-elect sila in the same meeting wherein the increase in the number of directors or trustees is authorized. If it is provided for in the notice of meeting na dun na rin sila mag-e-elect ng mga bagong stockholders or members to fill the vacancy which is created by the increase in the number of members of the board. What else? Number 3, if the vacancy occurs other than by removal or expiration of term. So, if the vacancy occurs other than by removal or expiration, anong bang example niyan? Death, resignation, abandonment, or disqualification. So, other than by removal or expiration, if the remaining directors or trustees do not constitute a quorum. Remember, class, here that the vacancy will be filled by the stockholders or the members. Halimbawa, 5 silang director, tapos yung isa namatay, tapos yung isa inabandon niya yung kanyang office, tapos yung isa nag-resign. So, yung natirang 2, remember here, class, the reason for vacancy is not removal, not expiration. Kasi pagka yung 2 yon, matik, stockholders, members ang mag-fill ng vacancy. But here in number 3, yung example ko, may nag-resign, may namatay, may nag-abandon ng kanyang position. Here, class, the vacancy is not by other than by removal or expiration. Not by removal, not by expiration. But since the remaining directors, 2 na lang sila, do not constitute a quorum, they cannot fill the vacancy. So, they have to refer it to the stockholders or members. What else? Number 4, if the vacancy may be filled by the remaining directors or trustees, but the board refers the matter to the stockholders or members. Again, in number 4, the reason for the vacancy is not by removal, not by expiration, and not by increase of the number of members of the board. Except that, so pwede talagang i-fill ng remaining directors or trustees, and meron din silang quorum. Kumbaga, pwede nilang i-fill yung vacancy. But remember here in number 4, the matter is referred to the stockholders or members, meaning the remaining directors or trustees, even though they constitute a quorum, they are not interested to fill the vacancy. Ayaw nilang bumoto, ayaw nilang mag-appoint. What else? In case of members of the board, they will fill the vacancy only if, number 1, they constitute a quorum. And the reason for the vacancy is not removal and not expiration of the term. Meaning, papasok na naman tayo dun sa death, resignation, abandonment, or disqualification. So, if the board, there is still quorum, pwede nilang boto yung kanilang, yung mga replacement directors or trustee. So, when to elect yung replacement? So, this is actually a new part that they added to this provision. So, if due to term expiration, the election should be held no later than the day of such expiration at a meeting called for the purpose. So, pagka nag-expire, dapat within the day of expiration, makapag-elect ka na ng replacement. What else? In case of removal of a stockholder or member in removal by the stockholders or members of a director or trustee as provided for in section 20, ano bang section to? Section 27. Remember, class, that the election may be held on the same day of the meeting authorizing the removal if this fact is stated in the agenda and notice of the said meeting. So, kung nandun naman sa agenda nila, tapos meron namang proper notice that they will elect already the replacement dun sa tatanggalin na director or trustee, yun, pwede na nilang doon i-elect at the same meeting. What else? In all other cases of vacancy, the election must be held no later than 45 days from the time the vacancy arose. So, may nag-resign, so 45 days from the time that the director resigns. Yan. What else? The directors can also create an emergency board. So, yung emergency board, class, is the remaining directors or trustees, wala na siyang, they do not constitute a quorum, but there is a need for emergency action to prevent grave, substantial, and irreparable loss or damage to the corporation. So, yung vacancy is temporarily filled by the officers, by the unanimous vote of the remaining directors or trustees. So, yun ang kailangan nating tandaan. So, yung term tenure nila is for a limited period. The purpose is limited purpose nga. Yun nga lang, emergency action necessary. And remember, class, that it will cease after the emergency or upon election of the replacement director or trustee, whichever comes earlier. So, after na-create yung emergency board, SEC must be notified within 3 days and also state the reason for the creation of emergency board. So, the requisites for creating an emergency board: number 1, wala nang quorum ang directors or trustee. Number 2, emergency action kailangan. Number 3, the action is necessary to prevent grave, substantial, irreparable loss or damage to the corporation. Temporary replacement must be an officer of the corporation and elected by unanimous vote of the remaining directors or trustee. Meaning, lahat sila, they approve na itong officer na to will become a temporary member of the temporary replacement. Yan. What else? Notice must be given to the SEC within 3 days from the creation of the emergency board. How about compensation? As provided for under Section 29, the general rule is that directors or trustees shall not receive compensation as directors or trustees except for reasonable per diems. Yun ang tandaan natin. Wala talaga silang compensation as a general rule. Meron lang silang allowance. So anyway, the definition for compensation and per diems, nasa book niyo yan. Please take a look at the footnotes. So the exceptions, pwede silang magkaroon ng compensation if authorized in the bylaws. Yan. So if there is authorization in the bylaws for compensation of directors or trustees, dun sila magkakaroon ng compensation. If none, wala silang, they shall not receive any compensation. What else? Stockholders representing at least majority, OCS, majority of the members, they vote to grant compensation to directors or trustees at a regular or special meeting. So, majority lang, pwede nang magkaroon ng compensation ang directors or trustees. However, class, the compensation obviously may limit. So, if the compensation, dalawang paraan lang naman to give compensation if it is provided in the bylaws or if there is majority vote of the stockholders or members. But the limit is The total yearly compensation of directors shall in no case exceed 10% of the net income before income tax of the corporation during the preceding year. So please memorize this one. 10% of the net income before income tax of the corporation during the preceding year. Sometimes they ask this one, pinapalitan lang nila yung in no case, pinapalitan nila yung salitang exceed, yung net ginagawa nilang gross, yung before ginagawa nilang after, etc. etc. Preceding ginagawa nilang current, etc. So please memorize this phrase. Shall in no case exceed 10% of the net income before income tax of the corporation during the preceding year. So, yun ang tandaan natin sa limit. What else? Obviously, the directors or trustees shall not participate in the determination of their own compensation or per diems. Corporations which are vested with public interests, as I've already enumerated a while ago, shall submit to the shareholders and also the SEC annual report of total compensation of the directors or trustees. Section 29 likewise talks about per diems of directors or trustees. So, yung per diems, remember these are allowances. Now, in case of per diems, even if not authorized in the bylaws or there is no stockholders resolution granting the same to directors or trustees, they are entitled to receive yung allowances na ito. And for the purposes of the 10% limitation, hindi binibilang yung per diems granted to directors or trustees. What else? Compensation of corporate officers. So, dalawang klase ang corporate officers. Corporate officers who are not directors. So, remember, they are entitled to receive compensation because they perform valuable service for the corporation. There is an implied promise by the corporation to pay reasonable compensation for services rendered even if there is no express contract. Principle also applies to employees hired by the corporation. In case of corporate officers who are also directors, as a corporate officer, remember, they are entitled to compensation. Also, as directors, they are entitled to reasonable per diems. So, the amount of the compensation may be fixed by a mere board resolution. Yun ang tandaan natin sa corporate officers who are also directors. Yan. For liability of directors, trustees, or officers, we have to first take note of the fiduciary relationship between the corporation and directors, trustees, or officers. So, if you are elected as a director, trustee, or an officer, you occupy a relationship of which is fiduciary in nature with the corporation. So, merong certain power and subject to certain duties sa management ng properties ng corporation, and kailangan i-handle with utmost good faith ng directors, trustees yung affairs ng isang corporation. Also, in line with that, remember the threefold duties of directors: duty of obedience, duty of diligence, and also duty of loyalty. Now, please take note also of the exceptions to the doctrine of corporate entity. Remember the doctrine of corporate entity. The personality of the corporation is separate and distinct from the personality of the stockholders, members, directors, trustees, officers who comprise yung corporation. However, in Section 30, these are exceptions, meaning there is a personal liability on the part of directors or trustees, and that liability, kung marami sila, is also solidary with the corporation. So, exception to sa, again, doctrine of corporate entity. So, yung number 1, director, trustee, or officer willfully, knowingly assents to patently unlawful acts of the corporation because the act is unlawful. Not only in ultra vires, the act is also unlawful. So, any director, trustee, or officer who willfully votes for or assents to that act is solidarily liable. What else? Number 2, director, trustee, or officer is guilty of gross negligence or bad faith in directing the affairs of the corporation. So, pagka nagkaroon ng resulting damages suffered by the corporation, suffered by the stockholders, suffered by the members or third persons, remember, directors, trustees, or officers shall be guilty of gross negligence and they shall be liable solidarily. What else? Number 3, in case director, trustee, or officer acquires personal or financial interest in conflict with his duty. If there are damages or injuries caused to any stockholder or to the corporation, remember, itong mga director, trustees, officers na to will be solidarily liable again. Number 4, director or officer in case of a stock corporation consents to the issuance of watered stocks. So watered stocks are stocks that are issued as fully paid when they are not actually fully paid, or they are not paid at all. So they are issued for less than the par. So pero ang issue niyan, meron ng certificate of stock yan at saka lumilitaw na fully paid sila. So anyway, we will learn more about watered stocks in Title 7. But what you have to remember right now is that in case of issuance of watered stock, any director or officer who consents to that is liable solidarily. And also, kung di ka naman nag-consent but you are aware of the issuance of the same, meron pa ring liability. What else? Contractual agreement to be solidarily liable with the corporation. So here, probably injury or damage caused to third persons. So the director, trustee, or officer will agree to be solidarily liable with the corporation. The liability here is based on contract. What else? Number 6, director, trustee, or officer is made personally liable for corporate actions by specific provisions of law. So that is what you have to remember. These are the exceptions to the doctrine of corporate entity. So Section 31 talks about self-dealing directors. So usually ang sections 31, 32, 33, and I think, if I'm not mistaken, yes, 33. Usually merong mga examples, but since I'm running out of time, yung examples will be discussed on Saturday. So anyway, in case of self-dealing directors, please take note of the definition. Any director, trustee, or officer, including yung kanilang spouse, relative within the 4th civil degree of consanguinity or affinity, who enters into a contract with the corporation. Kung saan siya director, trustee, officer, stockholder, or member, siya ay self-dealing director, trustee, or officer. So meaning, director ka sa corporation na to, tapos ang kadil mo is yung sarili mo din in a personal capacity. So you are representing the corporation as a director, but you are also dealing with yourself in a personal capacity. Kanyapin siya ay self-dealing director, trustee, or officer. Now, as a general rule class, Section 31 will render voidable at the option of the corporation yung contract with a self-dealing director, trustee, or officers, including spouse and relatives. So, bakit? Because of the fiduciary nature of yung position ng director, trustee, officer. Kaya usually voidable ito at the option of the corporation. So kung kahit na tandaan nyo rin dito na it does not require that the corporation suffers injury or damage as a result of the contract. As long as the corporation is not comfortable with this kind of transaction, they can render it voidable. So pwede nilang ipa-annul yung contract na ito kasi voidable on their part. The only party who can ask for annulment here is the corporation. So exceptions, obviously there are always exceptions. So here in the following cases, the contract is no longer voidable, but it is valid and cannot be set aside or cannot be annulled merely because of the relationship of the parties. In case of number 1, all the conditions in Section 31 are present. So remember, in Section 31, there are actually several conditions na kailangan na i-discuss. So in Section 31, the first condition is that doon ba sa meeting to approve yung contract with the self-dealing director, yung kanyang presence, yan, presence of such director or trustee is not necessary to constitute a quorum. So, let us say A is a self-dealing director. Director siya sa A corporation. Tapos nakipag-deal siya sa sarili niya in a personal capacity. Now, in the meeting to approve the contract with in the meeting of A corporation to approve the contract with A. Yan. So, let us say 5 ang directors. O sige na, 10 na lang para mas madali. So, kung ang tanong dyan is kung halimbawa absent si A doon sa meeting na yon, tinanggal natin yung kanyang presence, mayroon pa rin bang quorum? Now, if ito yung first condition. Now, if there is still a quorum, pinasa mo yung first test. Now, the second test is that if the vote of such director or trustee is not necessary for the approval of the contract, in the same meeting wherein there are 10 directors, tapos let us say nag-attend si A para syempre gusto niyang mag-vote to approve yung contract with himself. Remember here class that if sa second test, if tinanggal mo yung boto ni A, yung contract ba ma-approve pa rin? So kung ma-approve pa rin, remember class that the second test naipasa. What else? Number 3, contract is fair and reasonable. Common sense na lang yan. So, kung naipasa mo lahat ng test na yun, yung 3 test na yun, remember, your contract is no longer voidable. But the contract with the self-dealing director is considered a valid contract and the corporation cannot annul it later on. Also, in addition to that, para pagka corporations vested with public interest, the contracts must be approved by 2/3 of the entire membership of the board. Hindi lang bastang majority or plurality. Kasi di ba sa board hindi naman tinitignan dyan yung financial interest. Ang tinitignan dyan is per head voting. Pero in case of corporations vested with public interest, dapat 2/3 ng membership ng board ang mag-approve noong contract with a self-dealing director. And also, include to that yung at least majority of the independent directors. Remember, independent directors should comprise 20% of the total membership of the board of corporations vested with public interest. So, kailangan makuha mo yung majority ng 20% na yon. Para yung contract mo, kung ikaw yung self-dealing director, ay hindi na voidable but will become valid and cannot be set aside or no longer annulable. What else in case of an officer? Ito, if the contract is with an officer, what you have to remember is that the officer has been previously authorized by the board of directors. Now, if there is authority, kailangan the contract is no longer voidable but is perfectly valid, cannot be set aside anymore. Number 2, exception. If not all the conditions set forth in the preceding enumeration, yung mga pinagsasabi ko kanina, not all are present, but yung board does not question the validity of the contract. So, obviously, remember, a voidable contract is valid until it is annulled. If you do not question the validity of a voidable contract, it will remain a valid contract. And also, tandaan nyo, may prescriptive period dyan. Pagka lumagpas na sa prescriptive period, hindi nyo na rin mako-question yan. What is the prescriptive period? Nakalimutan nyo na naman. 4 years. So, as a general rule. What else? Number 3, the contract again is can no longer be set aside if in case of a contract with a self-dealing director, trustee, or officer, including spouses and relatives, tapos any of the first 3 conditions, hindi na naman kumpleto yung first 3 conditions, but the contract is ratified. So ratification again cleanses the contract of its defect from the beginning, so it can no longer be set aside or annulled. Remember, ang voidable contract pwedeng ipa-annul, pwedeng i-ratify. Pagka ni-ratify, hindi na pwedeng i-annul. Pagka in-annul, hindi na pwedeng i-ratify. So, yun ang self-dealing directors, trustees, and officers. To add to that pala, requisites for ratification. Number 1, first, any of the first 3 conditions set forth in paragraph 1 is absent. So, yung vote is not necessary, presence is not necessary to constitute a quorum, fair and reasonable. any of the first three conditions is absent. Number 2, full disclosure. Actually, may mali dyan eh. Any of the first two dapat yan. Full disclosure of the adverse interest of the directors or trustees. And number 3, to ratify, there must be 2/3 OCS or 2/3 of the members, 2/3 votes of the OCS, 2/3 votes of the members, and contract is fair and reasonable. So sabi ko nga, dalawa lang talaga yun eh. Hindi naman dapat first three. Because the third test is that the contract is fair and reasonable. So kung yun ang element na nawala, hindi mo pwedeng i-ratify talaga yung contract. Because in the requisites for ratification, it is clear that the contract must be fair and reasonable under the circumstances. Also, to add to that, Section 31 does not specify whether the vote of the self-dealing director or trustee is counted in the ratification. However, if you read Section 52, director or trustee who has a potential interest in any related party transaction must recuse from voting. So, dapat hindi talaga siya bumoto in the first place according to Section 52. On the other hand, Section 35 talks about interlocking directors. So, remember, in case of interlocking directors, ang definition niyan, one sum of all of the directors in one corporation are also the directors in another corporation. So, two corporations obviously are involved in this scenario. So, one corporation, yung mga directors niya are the same doon sa isang corporation. Let us say A is a director in corporation A is also a director in corporation X. So, here, A is an interlocking director. Now, contracts between corporations with interlocking directors, as a rule, they are valid contracts. Even if pareho yung kanilang sets of directors, as long as there is no fraud and the contract is fair and reasonable under the circumstances. But this will only apply if yung interest ng interlocking directors in one corporation is substantial and yung interest in another corporation is substantial also. The rule will apply, valid yung contract, if the interest is nominal in one, nominal in another also, in the other also. Now, if the interest of the interlocking directors in one corporation is substantial, meaning it exceeds 20% or para mas madali, 21% pataas. And yung interest niya sa isang corporation ay nominal naman, 20% and below. Remember here, class, that dun mo i-apply yung test na nakita natin sa self-dealing directors. And in which case, class, yung if hindi nyo naipasa yung test ng self-dealing directors, the contract may be annulled on the part of the corporation wherein the interest of the interlocking directors is nominal. So, yun ang kailangan yung tandaan. So, for validity of the contract, there is no fraud. Contract is fair and reasonable. Substantial interest in both corporation or nominal interest in both corporations. Yan. So, in this case, valid yung contract na yan. So, in case there is substantial interest in one corporation and nominal interest in another, tapos pumasa siya sa mga tests sa self-dealing directors. Remember the test in self-dealing directors. Yung presence ba ng mga interlocking directors hindi kailangan para mag-constitute ng quorum. Yung vote ba ng interlocking directors hindi kailangan para i-approve yung contract. And the contract is fair and reasonable. Pagka naipasa niya lahat ng tatlong test na yan, remember the contract is valid. Now, if hindi naipasa yung test, again, kailangan yung tandaan na the contract is voidable at the option of the corporation where the interest of the interlocking directors is nominal. So, yun ang tatandaan natin. Anyway, examples on Saturday para mas madaling ma-illustrate kasi mahirap yung illustration sa ganito. What else? Disloyal director. So, in case of disloyalty of a director, we will look to Section 33. So, yung disloyalty consists of any act where the director is personally benefited at the expense of the corporation. So here, there is a betrayal of the fiduciary relationship between director and corporation, and yung personal benefit ng director here causes prejudice on the part of the corporation. So please take note also here of the doctrine of corporate opportunity. So yung doctrine of corporate opportunity, a director who because of his office acquires for himself a business opportunity, take note of this, which should belong to the corporation, and he obtains profit thereby to the prejudice of the corporation. Yan ay disloyal director. So ang consequence niya, yung disloyal director will account to the corporation all such profits by refunding the same even if he risks his own funds in the venture. So yun ang tandaan nyo. Doctrine of corporate opportunity. The corporation has the opportunity to undertake this business, pero anong ginawa ng director? He acquires for himself yung business opportunity which should belong to the corporation. So ito ay corporate opportunity na ninakaw ng isang disloyal director. Anyway, what you have to remember also, in addition to that, any profit obtained by the disloyal director must be refunded to the corporation unless ratified by 2/3 OCS. So kung na-ratify yan, hindi na kailangang ibalik yung profit, hindi na kailangang i-refund yung profit dun sa corporation. So that requisites for the application of the rule, there is an opportunity which presented itself to the corporation and the corporation is actually able to avail of the opportunity. So bago mo i-apply yung doctrine of corporate opportunity, these two must occur. Kailangan merong opportunity which presented itself to the corporation. Corporation talagang doon talaga binigay yung opportunity and kaya niyang i-undertake yung opportunity. Yun ang number 2. But obviously the doctrine is not available if the director is engaged in a distinct enterprise of the same general class of business as the corporation, as long as he is in good faith. So obviously dahil pareho general class of business, pareho talaga, kailangan exempted na yan sa doctrine. When else, number 2, opportunity is not essential to the business of the corporation. There is no exploitation of the opportunity by the director or officers, and wala namang employment ng company's resources. So wala ring competition na nangyayari between the corporation and the director. So what else? In short, sa number 2, wala talagang damage cost to the corporation. That's why hindi mag-a-apply yung doctrine. Number 3, property or business opportunity ceases to be a corporate opportunity and transforms into a personal opportunity. When will that happen? When the corporation is no longer able to undertake the business because of financial constraints, etc., etc. So here, the corporate opportunity is no longer corporate but personal na lang on the part of the director. In this case, you will not apply the doctrine of corporate opportunity. Ratification by the stockholders, sabi ko nga sa inyo, para hindi na i-refund yung profit, pwedeng i-ratify ng stockholders 2/3 OCS, and also again silent ang section 33 whether or not the vote of the disloyal director is allowed in the will be counted in the ratification of his disloyal act. However, again, let's put into consideration section 52. Director who has a potential interest in a related party transaction must recuse from voting. Dapat hindi na siya bumoto in the first place. So section 34 talks about the executive committee. So please take note of the definition of an executive committee: body created by the bylaws, composed of not less than 3 members of the board, and has all the authority of the board of directors to the extent provided in the bylaws. So ang executive committee, ito yung kumikilos in the meantime na hindi nagmi-meeting ang mga board of directors. So an executive committee, remember, it will assure prompt and speedy action and solution to important matters without the need for a board meeting, especially if hindi pa kapag-hold ng meeting. So yung executive committee manages operations of the corporation in between meetings of the board, and nare-reduce yung workload ng board of directors or trustees. So also take note of the express provision in the bylaws. Magkakaroon lang ng executive committee if provided for expressly in the bylaws. Yan. So, they can act on specific matters which can be acted upon by the board, and also yung mga matters which are delegated by the board or by the bylaws, except matters with respect to only yung board ang pwedeng mag-decide, which we will enumerate later on. What else? Also, committee contemplated here should be distinguished from other committees. Yung other committees kasi can be created by the board itself. Now, yung executive committee under Section 34 should be created by a provision in the bylaws. So, what else? Restrictions on power. So, powerful as the board actually performs certain duties of the board and it is acting for the board. So, remember, class, ang executive committee obviously can bind the corporation. Yan. Quorum and voting. So, in case of quorum, ang requirements is majority of the members of the committee, regardless of whether or not they are members or non-members of the board of directors. So, it will constitute a quorum. Now, in case of voting, hindi ko na ilagay yung tungkol sa voting, it is essential that the executive committee acts by majority vote of all its members. So, majority vote ng members to approve an action. So, what else? Membership. Non-members of the board may be appointed as members of the executive committee, provided that there are at least 3 directors or members of the board. So, matters not within the competence of the executive committee. Number 1, approval, any action which will require the approval of the shareholders as well. Filling of vacancies. Ang pwede lang naman mag-fill ng vacancies are stockholders, in the cases provided by law, and yung board of directors if they constitute a quorum and the reason for vacancy is not because of removal or not because of expiration of the term. What else? Amendment or repeal of bylaws, adoption of bylaws. Ang board lang ang pwede gumawa niyan. What else? Amendment or repeal of any board resolution which is not so amendable or repealable. What else? Distribution of cash dividends to the stockholders. Kailangan ng board approval ng board yan. And also, please take note of special committees, and again, under Section 34, the directors may create special committees, may be permanent, may be temporary, and they can also determine the term of the members, composition, compensation, powers, and also responsibilities. So, that's it for Title 3. Please stand by for Title 4 class. Thank you.